Welcome to all of you to this DNI Initiative session with our special guest of today, Jeff Wynne. Today, we're going to focus on the recent progress on the MLETR front, mainly with regards to the policy side, but we will also cover some of the technology side as well, focusing today on the standardized wording for negotiable instruments and the EPU that we released almost two years ago. I'd like first to introduce our speaker today, Jeff Wynne, who is a partner with Sullivan and member of the DNI Initiative. Jeff has been a primary contributor to the DNI Initiative with the work that he will present to us today. Member also of the TFD Initiative, and we will talk about the TFD Initiative on Thursday as we have the member meeting on the latest developments. Today, we're going to, as I said, talk about policy, legal developments, and also the technology side. This session, as usual, is recorded. I have decided this time to organize it as a meeting, so you are all basically able to intervene, to speak, but I'd like to ask you all to basically mute yourself so we avoid any background noise. On my side, I'm an independent consultant as Customer Advisory, and I'm chairing the FinTech Committee of the International Trade and Forfeiting Association. Here is our agenda for today for Jeff and I to cover. I will first start with a brief introduction on the DNI Initiative and what is our industry ambition, focusing then on the new layers of value to implement MLETR and to achieve electronic transferable records and digital negotiable instruments. Jeff will then focus specifically on the electronic payment undertaking for promissory note and bill of exchange, and I will cover, time permitting, the additional technology deliverables from the DNI Initiative, namely the dDOC specifications. So first, the DNI Initiative. So the goal of the DNI Initiative is really within ITFA to regroup all those players that are committed to contribute to the digitization of negotiable instruments. So NI stands for negotiable instruments and D stands for digital. You can talk about ENI sometimes as well, electronic negotiable instruments. It's really a focus on the corporate to bank relationship and how to digitize the various types of negotiable instruments, not only bills of exchange and promissory notes, but also bills of lading, warehouse receipts, and a few others that are in that specific category. So the goal is really to move the world of the trade space and those specific instruments from the use of paper to the use of electronic means, but thereby also adding additional value to those instruments, like adding security, adding user experience, improving the user experience, and enabling originators, banks and non-bank originators to enhance their product differentiation by being more indeed digital and offering more value to their clients thanks to new technologies and new policy decisions that we will discuss today. So the DNI Initiative is one of the two major FinTech initiatives that we set up as part of the FinTech Committee. And the TFD Initiative is definitely focusing on the distribution side, making sure trade is becoming an asset class accessible to institutional and retail investors. We will talk about this on Thursday. The DNI Initiative is positioned as a community of technology firms, but mainly financial institutions and potentially also their corporate clients that are really driving the adoption of new technologies to enable digital negotiable instruments. On the left-hand side of this slide, you see basically how we focused on working with specific jurisdictions, countries to help upgrade their national laws according to the model law for electronic transferable records that we all know, or I assume we all know. We have worked with various parties such as the ICC, of course, the United Nations, UNCITRAL, of course, because they are the ones who drafted the MLETR, and also at country level, specific bodies that are basically driving the change of national laws in their specific country. The work we have done and the approach we have taken has been endorsed by the ICC as part of the Digital Standards Initiative, the DSI, which is completely aligned with our goal, but which has a much broader scope, whereas on the DNI Initiative, we really are very specialized, as the title says. Today, we have indeed a series of community members, mainly trade technology vendors, but also banks and also law firms. I mean, the importance of law firms is undeniable, of course, as this is mainly a policy project first, and technology supporting the change of policy. Finally, on the technology side, we also have a sandbox, a testing portal where you can check out how the new technology can enable digital negotiable instruments, and you can create documents and transfer ownership of those documents using a free-to-access sandbox that we call the dDOC Notary Service and the dDOC Manager. So now, the layers of value, as I like to put it, before we listen to the main part, the EPU from Jeff, I'd like first to position it as part of the work we have achieved so far, because we launched this initiative in mid-2019, and it's important to see how all those components fit together. So I think there are three layers of value that we collectively are working on. There is, of course, the changing the law, which is making sure that those instruments become negotiable under common law. So changing the law has progressed. We have the Electronic Trade Documents Bill, I think that's the right name, that has been indeed finalized, and that has to become an act after the votes have occurred. We'll hear more from Jeff on this. We have also, so that's really the top layer, because it's the law. We have then standardized wordings, which and what I would call business formats is to structure the text around a particular instrument. And this is where indeed we have focused on the ITFA side, mainly on the bill of exchange and promissory notes, whereas, as you will see on the next slide, there are other associations focusing on the bill of lading. And we'll talk about that a bit later at the end. And we have the appropriate technology as the third layer. And I put it at the bottom because the technology is only as valid as the legal system allows it to be valid, which is to digitize documents in the most interoperable way. And this is why we developed the dDOC specifications to explain how indeed existing and very recent technologies, new technologies, can be combined to achieve interoperable electronic records. So from an implementation point of view, over the last 2 years, we have worked indeed on demonstrating how specific technologies are compliant with those schemes, like the Enigio technology with Trace Original, enabling to achieve MLETR compliant interoperable electronic records. So making sure that the digital document.
Okay, so I as a beneficiary or an applicant will put up a request for discounting of an.
Sorry, so I have to mute the participants. So we have worked on demonstrating how the Enigio technology achieves this MLETR compliance for interoperable electronic records. It can be applied to bill of exchange, promissory notes, bills of lading, and other negotiable instruments. So as a generic technology to act as a technical envelope, an electronic envelope for those documents, but in the most interoperable way. And we have also from the start worked with Jeff to develop the EPU indeed, the standardized wording, to make sure that we have a solution for contract law, but also ready to accommodate the common law. What is missing in terms of deliverables, as you see from the slide, if you have a color screen, is the top layer, the common law, transforming the bill into the act, and that is expected for next year by now. I think again here we will hear more from Jeff on this. Now I am adding a fourth layer at the bottom just to highlight that at the transport level, exchanging documents, interoperable documents, such as the initial documents, can be achieved on any medium. It can be achieved on SWIFT, FILACT, which I launched in 2002, 20 years ago, in the payment space. So that's a file transfer service that all of the banks are using by now. It can be achieved on what German banks and French or Austrian banks are using, like EBIX, or it can be used also on traditional mechanisms like e-banking or new mechanisms like DLT, for those who want it. So that's a light blue here, because this is reusing those transport mechanisms. We don't have to change anything there. So that's an overview of how we are basically assembling pieces on the policy side, on the technology side, to help banks achieve MLETR and the digitization of negotiable instruments under contract law for now, or on the common law in the next year, as soon as the act will be available. So this is just setting the scene. I would like now to invite Jeff to tell us more about the EPU for promissory notes and bill of exchange, and where we're coming from, and what is the feeling, the general feeling of Jeff around how the industry has evolved on this topic so far. Jeff, over to you.
Andre, thank you. Go on to the next slide. Just before I sort of go into this, I do see a sort of legal crossroads. And it's a crossroads where, in some ways, as Andre has already started saying, the law is moving ahead to facilitate what we're talking about, which is the digital asset, in this case, the digital promissory note. And the question that I really pose to a number of the audience as well is technology ahead? Because I had always assumed that from a technological point of view, you would always be ahead of the law, or in fact, is technology going to lag behind the legal change and run to catch up? Because Andre has used some interesting words like interoperability, or as a key word, because what we're going to have to demonstrate is how the technology then reflects what the law is going to say, and I'll come on to that. So this is focused essentially on how we could get the equivalent of an electronic promissory note. And when we started, this quote from me, which was way back in 2019, as Andre said, and then 2020, we put our thinking caps on as to how we could deal with issues to create, in simple terms, a digital bill of exchange or promissory note under the Bills of Exchange Act of 1882, which I said, unsurprisingly, had not foreseen the digital world. And so we looked at what was needed to achieve the substantive equivalent. And that's an important phrase to remember as I go through the next couple of slides, because what we want is an electronic payment undertaking that exists only in the digital world. There must be no paper original. And the idea then is, because we have created this, that we will have the ease of creating and transferring and getting paid under an electronic payment undertaking. That's, after all, what those of us involved in trade finance want to achieve. Next slide, please. Now, I asked Andre to include this as a Sullivan badge slide, not because I wanted the publicity, but to explain to you where we started from in 2019 and 2020. And what we looked at is, could we have, under the existing 1882 Act, and I'm talking about English law here, a deliverable electronic promissory? And as you will see, what happened was it became very clear that the eminent lawyers who constituted the task force said you cannot have an electronic negotiable instrument under the Act as it currently stands, because you need a transfer of possession and you can't have that. As a result, we suggested the creation of this short form electronic payment undertaking, achieving the substantive equivalent. And as you can see from the penultimate bullet point, we wanted to create this electronic promissory note as an irrevocable payment undertaking, freely assignable to a holder in due course. Those of you who are familiar with promissory notes and bills of exchange know the importance of being a holder in due course as a matter of Bills of Exchange Act, because the holder in due course knows there is no defense that the issuer has to making payment. So that's what we had to achieve. And then the challenge, which Andre and the fintech side have then had to take up, is to achieve that last bullet point, which is the secure system, that you can only have one valid original and allowing for a transfer. So let's move on. Next slide, please. So let's take this apart. Under English law, can we achieve that equivalent EPU, signed, written, but in digital form, alternative, achieving the negotiable equivalent to for an electronic negotiable instrument? And the answer is, well, actually, I won't get into signing because English law is very flexible about digital signing. So let's move on to the requirement of an irrevocable unconditional promise to pay, which some of you will say also independent, which I agree with. And it's a sum certain on a specific date or on demand. For those well versed in the Bills of Exchange Act would know that that is exactly the definition of a promissory note. We then came on to B, C, and D to achieve a holder in due course. And as I explained there, the electronic system has to create an equivalent to the holder in due course. So the assignee, i.e. the party to whom that promise is transferred, knows that the issuer will not have a defense to non-payment to the person who is then the holder, i.e. the assignee. In other words, what we are achieving is a contractual solution under English law to replicate what would have been the paper. And I'll come back to that in just a moment. So the concepts that we're trying to cover, again, Andre mentioned one, which is the electronic record. So the idea is that the promise to pay is encompassed in an electronic record that reflects effectively the three elements: the exclusive control of the electronic record by a single person. In other words, that is trying to replicate paper. So if I stop here, what do you know about paper? Well, the answer is, if I have the paper, I clearly possess the piece of paper. I'm the only one who then has it. And if I wanted to transfer that piece of paper as a matter of English law, if that were a promissory note, I would do one of two things. I would either endorse it by signing on the back, please pay. And for those of you who were used to the forfeiting market, I would endorse it without recourse to me. So in other words, I would say, I own it, I transfer it to you, or I could create an endorsement in blank, i.e. I could then transfer that promise simply by delivering the piece of paper. Now, for various technical legal reasons, like not creating a currency, we steered away from bearer instruments. But what we were trying to reflect is the equivalent of that endorsement. And that then took us on to the wording. Next slide, please. Okay, now this looks horrendous, but let's try and break down the left-hand side. And if you look at the first paragraph, what that actually says is exactly the wording that you would expect a promissory note to say. The issuer irrevocably and unconditionally undertakes to pay the holder on the maturity date the principal sum without deduction at the payment place, waiving the need for anything else at all. For those of you very familiar with English law promissory notes and indeed bills of exchange, that wording will ring true. So what's the big deal? Well, the answer is, in our digital world, we need to go further than that, because that simply gets the piece of paper existing digitally. So what we then went on to say is that the holder of this electronic payment undertaking, magic words, authenticated by owning the private key, which corresponds to the public key in the electronic system, is the legal owner. So the holder is the party that has the private key. The public key was available to anybody who wants to look at what the promise says, but the only party that has the right to be paid, the right to transfer, is the person that has the private key. And so the next stage then says the holder may freely transfer the legal ownership to a third party, the assignee, and upon the agreement to transfer, the holder assigns the EPU, legal assignment as a matter of English law, and the instructions that are given to the electronic system, the transfer, says when this transfer is effective, the assignee is then given as a private key, again corresponding to the public key, but showing it as the owner. And the issuer then irrevocably agrees that upon that transfer taking place, it is notified as of the assignment, i.e. the English law concept of notice of assignment, and that gives the assignee the rights of the holder. And then, if you like, the legal gobbledygook bit, because this is the English law version, which has exclusive jurisdiction of the English courts or possibly arbitration. If you move to the right-hand side, this idea of on the right-hand side is then to reflect exactly the party details as you would view on the electronic system. And the question then about the payment details, which I have discussed with other people, is that whose payment details go in there? Where is the place of payment? Is it the first holder, or should we say it's the first holder or is notified by the assignee, so that the party that is the holder ultimately says to the issuer, this is where you have to pay me. And that, in a nutshell, is the wording that we suggest you need to achieve the equivalent in an electronic payment undertaking of an English law promissory note. So fintechs, pay attention, because you are key to this. Can you just go on to the next slide, please? For those of you who are looking at the time saying, I hope he's not going to do all that again, the answer is I'm not, because the only difference here is that the first paragraph of our bill of exchange reflects the difference between the bill of exchange, which is the order to the acceptor to pay rather than the simple promise to pay. But the rest of the steps that we have to take are based exactly on how we had constructed the EPU as a promissory note. So one way or the other, we have all the promises. And if you look on the right-hand side of this slide in the party details, you get to the issuer, acceptor, and first holder, and then you move along as we've said before. Okay, let's move on to the next slide. Now, I want to take a deep breath here because as I said to you, and as Andre said, we started in 2019 and 2020 with the DNI Initiative. What happened? Well, COVID happened, and COVID and some frauds and accelerated the view of a lot of parties that what we should do is to move much more quickly into the digitalization of assets, and in this case, into the digitalization of that promise to pay, that promissory note. And the effect of that is that English law, I say, leads the way. And the only reason I say that, apart from the fact, of course, that I'm an English lawyer, is that the Law Commission was very receptive to the idea of saying, let's create a relatively simple means of dealing with the problems of the transfer of possession that you have or you can't have when you have a digital promissory note or bill of exchange. And as Andre has mentioned, also a bill of lading, but I'm going to leave that for the moment. So what you need, and what English law said, and the Electronic Trade Documents Act, a very short act, says, is that in order to create the instrument as a digital instrument, you require that magic phrase, exclusive control. So if you can create a system whereby there is exclusive control of that electronic or digital promise to pay, then you can have a promissory note under an amended Bills of Exchange Act. And that means that as a matter of English law, we would hope and expect that when the Electronic Trade Documents Bill becomes an act, it will lead the way to our being able to go back to the wording of our electronic payment undertaking and simplify everything that is necessary to reflect exclusive control moving from the first holder to subsequent holders. And therefore we would not necessarily have to reflect the assignment wording that we have currently used and the notice wording, but the Bills of Exchange Act would say that in effect, the issuer of that promise to pay recognizes that the party that has exclusive control of the electronic record that represents that promise to pay is the party who gets paid. What's everybody else doing about it? Well, the answer is that Melita, the model law on electronic transferable records, has been adopted elsewhere. What of course is interesting when I talk about this is that Melita was produced by Untitled in, I think, way back in 2016. And with the exception of Bahrain, nobody paid very much attention to it until COVID and all the problems came up. Singapore embraced it, Abu Dhabi embraced it, and a number of other countries have embraced it. Looking at Singapore, Singapore has gone a stage further in passing laws to permit electronic transferable records, but as provided by registered technology providers who are prepared to certify the, if you like, the ownership of that electronic record, because that's important. In the US, as many of you know, Delaware law facilitates this, but the US is also moving to changes in law to allow the transfer of digital assets. But remember all the time that when we're looking at our simple promise to pay, the Bills of Exchange Act is a matter of English law and a lot of the common law countries of the world, or the Geneva Convention countries who've adopted the 1930 Geneva Convention need to look at making sure that as a matter of the local law, that you can have the concept of reflecting possession of the digital instrument by exclusive control of that electronic record. Now, of course, what's interesting is that there are lots of other ways of achieving digital payment instruments, but they all require contract. So as a matter of, and as I say, I concentrate on English law, but as a matter of contractual law, we can write rule books, which we have done. Within rule books, all the members can agree how they will deal with a digital payment instrument created within their rule book and how that instrument can be transferred. While all of this discussion was going on, I and others worked on the uniform rules for digital trade transactions, which also looked at electronic records, exclusive control. So if you like, we were ahead. So there are rules that you can adopt in relation to that. I'm now working with ITFA on some uniform rules for the transferable electronic payment undertaking. Again, a set of rules that you'll hear about in the months to come, which again, you can incorporate in your transactions to transfer an electronic payment obligation. So all the time, we are looking at what to do with digital assets and how to transfer them. And then only last week, 28th of July, the English Law Commission has come up with a paper for discussion, some 500 pages. So if you're an insomniac, it's probably good for you. But the paper is on digital assets with a suggestion, again, encapsulating the idea of control to replace possession. And I would say, watch this space in relation to all sorts of other developments. But if I can bring us back and conclude that I hope that I demonstrated that the electronic negotiable instrument, as we have promulgated, can work at the moment and is at least a way forward as a matter of English law and any other law that might embrace it, of creating that digital payment undertaking in the same way that we would have, if we could, a digital promissory note. And in order to achieve that, it is over to the technology providers to work out how we can achieve the exclusive control in a way that works. And Andre, if that's not a good enough segue for you, I don't know what is. Thanks.
Thank you, Jeff. Excellent. So indeed, we understand that the EPU is a solution for today to digitize negotiable instruments, certainly the bill of exchange and a promissory note under contract law and under English law, of course, but contract law. And in the future, we're going to be able to reuse the EPU or a subset of your EPU wording for the common law solution, because as we have systems and electronic applications exchanging data flows around electronic bills of exchange and promissory notes, we need the wording to be standardized. So effectively, with the EPU, we are creating those standards for systems to automatically recognize the wording that represent the negotiable instrument. So indeed, now exclusive control is definitely the purpose of the technology stream within the DNI Initiative. And this is where we have worked on a framework called the dDOC specifications that define what is expected from a technology solution to not only digitize documents, but to achieve all the requirements that Jeff just talked about, such as mainly the exclusive control and additional requirements. So the dDOC specifications are indeed a set of functional requirements, such as being able to for the technology to be open to any document format, because it's not just a bill of exchange and promissory notes, it can be the warehouse receipt, the bill of lading, and so on. Being able to be open to any financial institution or any corporate client, including SMEs. Also openness to third-party trade platforms, because trade is a complex workflow, a complex process that is handled by dedicated platforms on the corporate side, on the banking side, on the logistics side, and those electronic negotiable instruments have to be able to flow from one party to the other without requiring all of them to be connected to a common platform. Otherwise, we are back into creating a digital island, and we already have a lot of closed digital islands that do not interoperate. And that's definitely the focus of the dDOC specifications. So there are a few other capabilities. I will not go through all of them, but the one I want to highlight is the number 6 here. The document tracking has to be achieved via a public register, because as you are a recipient of an electronic negotiable instrument, you want to be able to check that this document is still valid. Has it been changed in the meantime? Has it been invalidated? Has it been transferred? Indeed, that's a change to another party. You want to be sure that the version you receive is the correct one. And this is what public registry, such as distributed ledger technology, achieves, but a public one, not a private one, because if it's a private one, again, we are into a digital island setup, which we want to avoid. So there is much more on those dDOC specifications, but if I want to summarize it in one go, the framework suggests indeed a digital container represented as an electronic file, because all IT systems can exchange file, and secured with electronic signatures and seals. And this is where exclusive control, all those requirements are achieved. And the digital container and the electronic signatures and the seals are the ones managing the private, the confidential data, the business data, and tracking all the changes that have occurred to the document when the document is updated, transferred, and so on, until it is invalidated. And then the tracking is achieved via a digital notary, and that's a public DLT, which is acting indeed as a common but completely open registry, whereby anyone can check that the version he or she received from a counterparty is still valid. And this is where the use of digital ledger technology brings its magic, because you can access such a system without being a registered user of that system. And that's why the use of public DLT is so important. And important to note also is that this digital notary is only a notary, but only contains hashes of the business data secured in the file, so that there is no business data getting into the public notary, the public registry, because otherwise you would have a data privacy issue. So only hashes of the documents are stored on the public DLT. So today, this is the one implementation we have achieved with Enigio, but of course it could be achieved by other companies, and it can be interfaced with other chains, because the world of blockchains is a vast world with many different chains, but today it is running on the proprietary Enigio ledger, which is a public ledger. Now, this piece of technology achieves what MLETR requires for contract law implementation, common law implementation, and benefits from all the technological progress achieved by the blockchain industry as a whole. And that includes the use of private keys, public keys, and so on to exchange the ownership and to secure the whole document. Now, very important on the right-hand side of the slide, this piece of technology, as I said, is just a file with a digital notary. It's very complex to build, but at the end of the day, it's only a file that parties and applications need to exchange. And this is where existing channels and systems like trade application vendors on the corporate side, on the logistics side, on the banking side, as well as channels like Swift, EBIX, and other e-banking and to deliver documents can be completely reused. And that's very important because we don't want to start implementing electronic negotiable instruments and change what is working. From a business case implementation and cost efficiency, we need to keep what's working and add incremental technology to deliver additional value, which is what the dDOC specifications achieved and what Enigio has implemented. Again, Enigio as a first vendor, there might be others in the future. The one that we can highlight also is the Singapore Trade Trust, which doesn't go as far as the dDOC suggests, but which achieves or follows the same principle, which are principles of the digital asset industry. So moving on, important to note that this framework is generic. That means it can support the wording developed by Jeff for bills of exchange and promissory notes, but it's ready because it's a generic envelope. It can also be used for other MLETR instruments or digital originals, such as the bill of lading standards developed by DCSA or BIMCO, or the DLPC developed by BAFT, or any future standards, business standards, content standards developed by the DSI or endorsed by the DSI as part of the wider scope of the ICC initiative. So we really have to see the dDOC as a technical envelope, a container, in the same way as you have physical containers in the transport industry. Here we have a file that is a container of a particular transaction, and that transaction is implemented or formatted according to the one or the other standards developed by the industry. And the two I want to highlight, because they are very recent, maybe you haven't noticed what happened 2 weeks ago only with BIMCO, is that they just published electronic bills of lading standards for bulk shipping. And that's typically the kind of additional business standards that developed by the logistics industry through BIMCO for bulk and through DCSA for container shipments. And those standards are typically business standards that can be integrated into a dDOC technology like Enigio. So just want to connect the dots here between what the industry players are doing on different fronts. So we're getting to the Q&A. Before we get there, again, you can get more information from the ICC DSI, which as I said, is provides a larger scope into trade digitization with a top-down approach on all, acting as a library of all standards initiative and deliverables. And on there, you will see that the DNI initiative has been endorsed by the ICC for negotiable instruments as well, next to the IMDA trade trust that you will find there as well. For more information on the dDOC specifications and the EPU that Jeff presented, we have on the ITFA website a manual of digital negotiable instruments that we first released in April 2020, and you will find on the website a second edition which has the same format, the same content, but the different format, which has been issued in June 2021. Finally, you have a lot of blogs on the LinkedIn through my profile, where we have covered all of the progress achieved since we launched the initiative. So a lot of blogs available to you. And we also have a community of members of the DNI initiative, including indeed law firms such as Sullivan, Clifford Chance, Square, Patent Box, and mainly technology vendors who are busy working to implement the dDOC specification through the collaboration with Enigio, and supporting, depending on their client requirements, the EPU wording, again, depending on what the banks are expecting. In Porto, at the ITFA conference, we will be showcasing initial implementations. So you may expect more news from the real world, the banks that are busy implementing those technologies and this wording. So more news to come by September for sure. So with this, I'd like to open to a few questions, and I see we have some comments. Thank you for your comments. And yes, this presentation and the recording will be available to you via the member area of the ITFA website, or I can send it to you by email. And then Niels is asking, I assume that the electronic promissory note and bill of exchange still needs to be signed digitally. Yes, I mean, digital signature is definitely part of the whole scheme, technology scheme. And
just to add on that, what's interesting is about English law, which is that signing, English law permits, if you like, smart contracts. So a click acceptance, as long as there's an intention to be bound, would work. So the problem for us is not how do I get it signed, because we can make that work relatively easily. We can create a method by which the issuer of that promise is bound by the promise. The challenge, which we're all trying to, is to how to transfer that promise from the first holder of the promise to others. And that's, I love your description, because that's exactly right. That's the envelope that we've got to work out, how we can have exclusive control and get that transferred. And then we really are moving this along very quickly.
Yes, and whilst we're waiting for additional questions, indeed, I often make an analogy between an Enigio-like technology and the electronic signature technology, because with electronic signature, you can indeed add the agreement through the signature on whatever kind of content, like a contract, a payment file, or a bill of exchange. However, you have no notion with electronic signature of ownership, of uniqueness of the document. And this is where indeed you need a mix, and what Enigio achieves is a mix of technologies to achieve all those additional requirements, getting us to indeed exclusive control of the asset. And actually, it's very interesting to see what's happened over the last 5 years, because the lawyers and the experts who developed the MLETR basically embraced concepts of digital assets that the blockchain industry has developed technically. So the two worlds are now meeting, at least through the trade finance industry. The policy experts and the technology experts have worked on similar concepts. And this is where we can say that the technology is ready to support or to achieve what MLETR requires. And certainly demonstrate how exclusive control can be implemented to be enforceable. And this is where the roles of law firms will be critical in the future, because the banks will expect law firms to confirm that not only the wording is correct, but the technology also achieved what the common law, the future act, will state. Any other question from our participants? I can also unmute some of you if you want, or I think you can unmute yourself. Feel free to add. Brandon is asking, any idea how far behind we in the US are? The US, we are working through the ITFA Terra task force, which is a task force where we meet on a quarterly basis on a call to update ourselves on the various policy developments. And on the US side, we got some interesting information recently through JP Morgan, through Merlin, who is involved in some of the work of BAFT and on the MLETR front. So there has been some progress, but I can't go into the details here. But Merlin Dowse, which is on that task force, is definitely a good contact for the latest on the US policy side.
I've been looking at that with some of my colleagues in the US, but I think that the changes to the Uniform Commercial Code are facilitating, but it requires states then to adopt the law. And for most of us, I think we would want New York law to follow what Delaware law seems to be doing, which the BAFT Digital Initiative is doing, is to facilitate exactly what we're doing in the UK, to create. Sorry, did you mute me by this?
Yeah, by mistake, sorry.
Yeah, sorry. So I was saying that New York law is probably the law that most of us would want to see changed to achieve the same effect of the digital promise and the exclusive control. It all comes back very much to the same concepts that each individual countries will need to adopt. And just one little go for all of you fintechs, because as Andre and I were speaking just before, what of course is interesting about exclusive control and the one document is, as Andre speculated, as to what happens if somebody steals the private key, in exactly the same way that we have the worry as to what happens if somebody steals that paper bearer note. And consequently, fintechs, you need to make sure that you accept some liability in relation to if you are confirming the ownership as being the holder of the private key, which is of course what the holder wants, and indeed what the issuer wants to know, that if I pay the party that holds the private key, am I discharged from my obligation to pay? So you're right, Andre, as lawyers, we've got a fair bit to do, but the idea is to alert all of you as to how we try and put that into the context of what we need.
Yep. Very good, Jeff, thanks. I have another question here. How is the electronic business document invoice going for approval in the English Parliament? I guess we're talking here about the bill, the electronic trade documents bill.
Well, it's in the it was in this Queen's speech as one of the bills that the government wants to make time for. I don't want to get involved in the party politics, but we're going to have for the next session of Parliament a new Prime Minister. In theory, because the Act is, in my view, well written and short, it should go through very quickly. And I think listening to what the ICC are saying is that parliamentary time is supposed to be found probably not in the current session or the session in the autumn, but in the early part of 2023. So it's a watch this space. But as I say, that's merely the start of where the law would then, if you like, be ahead of where the fintechs then need to catch up.
Exactly, and we often say trade finance is a bit behind in terms of digitization, but actually this is typically an initiative or a segment with those negotiable instruments where the latest technologies enable us to do more we could not have done that 5 years ago because those technologies were not as mature, and certainly not 10 years ago, because we didn't talk about such interoperable technologies at that time. We were only talking about private clubs, and we know that private clubs do not offer a scalable solution. So openness of technologies and interoperability, as I said, at the level of the messaging, the technical envelope, the container of the document, then the business standards, ITFA for bill of exchange, promissory notes, BIMCO for bulk, DCSA for container bills of lading, and additional standards for additional documents like warehouse receipts might be developed. And then the change of the law as a third layer. I think we have all the developments well aligned. And we see also through the Law Commission that there is much willingness on the UK side to push forward the digital asset technology, which is reusing exactly the same technology components that we are talking about here, but for other industries. So this is a nice convergence where trade finance can use the latest, very recent technologies like DLT, digital assets, private keys, and so on. And we have a few issues to sort out, Jeff, indeed, the liabilities of fintechs and other topics. So more work to be done for sure. But a great opportunity for us to leverage those additional technologies in a jurisdiction, the UK, which is very open to those new technologies, in contrast with the US, which is not as open to digital assets as we see what the SEC is doing so far. So thanks a lot for joining us today. It was great to have so many of you early August. Not an easy time for a deep dive into such a niche topic. You know us, feel free to reach out whenever you need some follow-up discussion, or if some of you want to join the DNI Initiative, feel free. It's one of those ITFA working groups. And we're looking forward to coming back to you with additional information. Mainly, our target is to deliver bank testimonials on those instruments to demonstrate how this can effectively be achieved. It's never easy to be the first ones, but some are really open to be the first ones. And those are the ones we will talk about in the coming weeks. So watch this space. As Jeff said, we have more to tell you going forward. Jeff, thanks a lot for joining us.
Thanks, everybody.
Pleasure to welcome you, to host you, and have a great afternoon or evening for Asia Pacific. Bye-bye.
Thanks, bye.
Thank you. Bye.